And my apologies to Sky King and John and Middleton and Bill. We'll get to your calls in a minute if you want to hang on. But Mueller's back after Jim Jordan forced him from the room. Well, I don't know if he forced him, but here's more of Mueller, KIDO Talk Radio.
Would you say that that action, the president tried to hamper the investigation by asking staff to falsify records relevant to your investigation?
I'm just going to refer you to the report, if I could, for review of that episode.
Thank you. Also, the president's attempt to get McGahn to create a false written record were related to Mr. Trump's concerns about your obstruction of justice inquiry, correct?
I believe that to be true.
In fact, at that same Oval Office meeting, did the president also ask McGahn why he had told, quote, why he had told special counsel's office investigators that the president told him to have you removed, unquote?
And what was the question, sir, if I might?
Let me go to the next one. The president, quote, criticized McGahn for telling your office about the June 17, 2017 events when he told McGahn to have you removed, correct?
Correct.
In other words, the president was criticizing his White House counsel for telling law enforcement officials what he believed to be the truth.
I again go back to the text of the report.
Well, let me go a little bit further. Would it have been a crime if Mr. McGahn had lied to you about the president ordering him to fire you?
I don't want to speculate.
Okay. Is it true that you charged multiple people associated with the president for lying to you during your investigation?
That is accurate.
The president also complained that his staff were taking notes during the meeting about firing McGahn. Is that correct?
That's what the report says. Yeah, the report.
But in fact, it's completely appropriate for the president's staff, especially his counsels, to take notes during a meeting, correct?
Well, I rely on the wording of the report.
Well, thank you, Director Mueller, for your investigation into whether the president attempted to obstruct justice by ordering his White House counsel, Don McGahn, to lie to protect the president and then to create a false record about it. It is clear that any other person who engaged in such conduct would be charged with a crime. We will continue our investigation and we will hold the president accountable because no one is above the law.
Thank you.
The gentleman from Florida.
Director Mueller, can you state with confidence that the Steele dossier was not part of Russia's disinformation campaign?
No, as I said in my opening statement, that part of the building of the case predated me, and by at least 10 months.
Yeah, I mean, Paul Manafort's alleged crimes regarding tax evasion predated you. You had no problem charging them. And matter of fact, this Steele dossier predated the Attorney General, and he didn't have any problem answering the question. When Senator Cornyn asked the Attorney General the exact question I asked you, Director, the Attorney General said, and I'm quoting, "No, I can't state that with confidence." And that's one of the areas I'm reviewing. I'm concerned about it, and I don't think it's entirely speculative. Now, if something is not entirely speculative, then it must have some factual basis, but you identify no factual basis regarding the dossier or the possibility that it was part of the Russia disinformation campaign. Now, Christopher Steele's reporting is referenced in your report. Steele reported to the FBI that senior Russian foreign ministry figures, along with other Russians, told him that there was, and I'm quoting from the Steele dossier, extensive evidence of conspiracy between the Trump campaign team and the Kremlin. So here's my question. Did Russians really tell that to Christopher Steele, or did he just make it all up and was he lying to the FBI?
Let me back up a second, if I could, and say, as I said earlier, with regard to the Steele, that's beyond my purview.
No, it is exactly your purview, Director Mueller, and here's why. Only one of two things is possible, right? Either Steele made this whole thing up and there were never any Russians telling him of this vast criminal conspiracy that you didn't find, or Russians lied to Steele. Now, if Russians were lying to Steele to undermine our confidence in our duly elected president, that would seem to be precisely your purview, because you stated in your opening that the organizing principle was to fully and thoroughly investigate Russia's interference. But you weren't interested in whether or not Russians were interfering through Christopher Steele. And if Steele was lying, then you should have charged him with lying like you charged a variety of other people, but you say nothing about this in your report.
Well, sir.
Meanwhile, Director, you're quite loquacious on other topics. You write 3,500 words about the June 9 meeting between the Trump campaign and Russian lawyer Veselnitskaya. You write on page 103 of your report that the president's legal team suggested, and I'm quoting from your report, that the meeting might have been a setup by individuals working with the firm that produced the Steele reporting. So I'm going to ask you a very easy question, Director Mueller. On the week of June 9, who did Russian lawyer Veselnitskaya meet with more frequently? The Trump campaign or Glenn Simpson, who was functionally acting as an operative for the Democratic National Committee?
Well, what I think is missing here is the fact that this is under investigation elsewhere in the Justice Department. And if I can finish, sir, and consequently, it's not within my purview. Department of Justice and FBI should be responsive to questions on this particular issue.
It is absurd to suggest that a operative for the Democrats was meeting with this Russian lawyer the day before and the day after the Trump Tower meeting, and yet that's not something you referenced. Now, Glenn Simpson testified under oath. He had dinner with Veselnitskaya the day before and the day after this meeting with the Trump team. Do you have any basis, as you sit here today, to believe that Steele was lying?
As I said before, and I'll say again, it's not my purview. Others are investigating what you
So it's not your purview to look into whether or not Steele's lying. It's not your purview to look into whether or not anti-Trump Russians are lying to Steele. And it's not your purview to look at whether or not Glenn Simpson was meeting with the Russians the day before and the day after you write 3,500 words about the Trump campaign meeting. So I'm wondering how these decisions are guided. I look at the Inspector General's report. I'm citing from page 404 of the Inspector General's report. It states, Page stated, Trump's not ever going to be president, right? Right. Strzok replied, no, he's not. We'll stop it. Also in the Inspector General's report, there's someone identified as attorney number 2. Attorney number 2, this is page 419, replied, hell no, and then added, viva la resistance. Attorney number 2 in the Inspector General's report and Strzok both worked on your team, didn't they?
Pardon me? Can you ask?
They both worked on your team, didn't they?
I know. I heard Strzok. Who else were you talking about?
Attorney number 2 identified in the Inspector General's report.
Okay. And the question was?
Did he work for you? The guy who said viva la resistance?
Peter Strzok worked for me for a period of time, yes.
Yeah, but so did the other guy that said viva la resistance. And here's what I'm kind of noticing, Director Mueller. When people associated with Trump lied, you threw the book at them. When Christopher Steele lied, nothing. And so it seems to be that when Glenn Simpson met with Russians, nothing. When the Trump campaign met with Russians, 3,500 words. And maybe the reason why there are this discrepancies in what you focused on is because the team was so biased.
Time of the gentleman has expired.
Pledged to stop
Mr.
Trump.
Jeffries of New York is recognized.
All right, that's a lib, so we'll take a break. You ever notice everything seems to be beyond Mueller's purview? Kevin Miller, KIDO Talk Radio. And here's a gentleman we've had on this program, Ken Buck of Colorado, interviewing Robert Mueller, KIDO Talk Radio.
Situations and not reaching a conclusion about the merits of the case, you unfairly shifted the burden of proof to the president, forcing him to prove his innocence while denying him a legal forum to do so. And I've never heard of a prosecutor declining a case and then holding a press conference to talk about the defendant. You noted 8 times in your report that you had a legal duty under the regulations to either prosecute or decline charges. Despite this, you disregarded that duty. As a former prosecutor, I'm also troubled with your legal analysis. You discussed 10 separate factual patterns involving alleged obstruction, and then you failed to separately apply the elements of the applicable statutes. I looked at the 10 factual situations, and I read the case law. And I have to tell you, just looking at the Flynn matter, for example, the 4 statutes that you cited for possible obstruction, 1503, 1505, 1512b3, and 1512c2, when I look at those concerning the Flynn matter, 1503 is inapplicable because there wasn't a grand jury or trial jury impaneled, and Director Comey was not an officer of the court as defined by the statute. Section 1505 criminalizes acts that would obstruct or impede administrative proceedings, those before Congress or an administrative agency. The Department of Justice Criminal Resource Manual states that the FBI investigation is not a pending proceeding. 1512b3 talks about intimidation, threats of force to tamper with a witness. General Flynn at the time was not a witness, and certainly Director Comey was not a witness. And 1512C2 talks about tampering with a record. And as Joe Biden described the statute as being debated on the Senate floor, he called this a statute criminalizing document shredding, and there's nothing in your report that alleges that the president destroyed any evidence. So what I have to ask you, and what I think people are working around in this hearing is, let me lay a little foundation for it. The ethical rules require that a prosecutor have a reasonable probability of conviction to bring a charge. Is that correct?
Sounds generally accurate.
Okay. And the regulations concerning your job as special counsel state that your job is to provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by your office. You recommended declining prosecution of President Trump and anyone associated with his campaign because there was insufficient evidence to convict for a charge of conspiracy with Russian interference in the 2016 election. Is that fair?
That's fair.
Was there sufficient evidence to convict President Trump or anyone else with obstruction of justice?
We did not make that calculation.
How could you not have made the calculation with the regulation?
The OLC opinion, Office of Legal Counsel, indicates that we cannot indict a sitting president. So one of the tools that a prosecutor would use is not there.
Okay, but let me just stop. You made the decision on the Russian interference. You couldn't have indicted the president on that, and you made the decision on that. But when it came to obstruction, you threw a bunch of stuff up against the wall to see what would stick.
Well,
and that is fundamentally unfair.
I would not agree to that characterization at all. What we did is provide to the Attorney General in the form of a confidential memorandum our understanding of the case. Those cases that were brought, those cases were declined, and that one case where the president cannot be charged with a crime.
Okay, but could you charge the president with a crime after he left office?
Yes.
You believe that you could charge the president of the United States with obstruction of justice after he left office?
Yes.
Ethically, under the ethical standards?
Well, I'm not certain because I haven't looked at the ethical standards, but the OLC opinion says that the prosecutor, while he cannot bring a charge against the sitting president, nonetheless he can continue the investigation to see if there are any other persons who might be drawn into the conspiracy.
Time of the gentleman has expired. The gentleman from Rhode Island.
Director, as you know,
before we get to the gentleman from Rhode Island, you're listening to former Special Counsel Robert Mueller testifying before the House Judiciary Committee on KIDO Talk Radio.
To curtail the special counsel investigation beginning at page 90. And by curtail, you mean limit, correct?
Correct.
My colleagues have walked through how the president tried to have you fired through the White House counsel, and because Mr. McGahn refused the order, the president asked others to help limit your investigation. Is that correct?
Correct.
And was Corey Lewandowski one such individual?
And again, can you remind me what character?
Well, Corey Lewandowski is the president's former campaign manager, correct?
Correct.
Did he have any official position in the Trump administration?
I don't believe so.
Your report describes an incident in the Oval Office involving Mr. Lewandowski on June 19, 2017 at volume 2, page 91. Is that correct?
I'm sorry, what's the citation, sir?
Page 91.
Of the second volume?
Yes.
And
a meeting in the Oval Office between Mr. Lewandowski and the president.
Okay.
And that was just 2 days after the president called Don McGahn at home and ordered him to fire you. Is that correct?
Apparently so.
So right after his White House counsel, Mr. McGahn, refused to follow the president's order to fire you, the president came up with a new plan. And that was to go around all of his senior advisors and government aides to have a private citizen try to limit your investigation. What did the president tell Mr. Lewandowski to do? Do you recall he dictated a message to Mr. Lewandowski for Attorney General Sessions and asked him to write it down. Is that correct?
True.
And did you and your team see this handwritten message?
I'm not going to get into what we may or may not have included in our investigation.
Okay, the message directed Sessions to give, and I'm quoting from your report, to give a public speech saying that he planned to meet with the special prosecutor to explain this is very unfair and let the special prosecutor move forward with investigating election meddling for future elections. That's at page 91. Is that correct?
Yes, I see that. Thank you. Yes, it is.
In other words, Mr. Lewandowski, a private citizen, was instructed by the President of the United States to deliver a message from the President to the Attorney General that directed him to limit your investigation, correct?
Correct.
And at this time, Mr. Sessions was still recused from oversight of your investigation, correct?
I'm sorry, could you restate?
The Attorney General was recused from oversight.
Yes.
So the Attorney General would have had to violate his own department's rules in order to comply with the President's order, correct?
Well, I'm not going to get into the subsidiary details.
Okay.
I just refer you again to page 91, 92 of the report.
And if the Attorney General had followed through with the President's request, Mr. Mueller, it would have effectively ended your investigation into the President and his campaign, as you note on page 97, correct?
Could you...
At page 97, you write, and I quote, taken together, the President's directives indicate that Sessions was being instructed to tell the special counsel to end the existing investigation into the President and his campaign, with the special counsel being permitted to move forward with investigating election meddling for future elections. Is that correct?
Generally true. Yes, sir.
And an unsuccessful attempt to obstruct justice is still a crime. Is that correct?
That is correct.
And Mr. Lewandowski tried to meet with the Attorney General. Is that right?
True.
And he tried to meet with them in his office so he would be certain there wasn't a public log of the visit.
According to what we gathered for the report.
And the meeting never happened, and the President raised the issue again with Mr. Lewandowski, and this time he said, and I quote, if Sessions does not meet with you, Lewandowski should tell Sessions he was fired. Correct?
Correct.
So immediately following the meeting with the President, Lewandowski then asked Mr. Dearborn to deliver the message, who's the former chief of staff to Mr. Sessions, and Mr. Dearborn refuses to deliver it because he doesn't feel comfortable. Isn't that correct?
Generally correct, yes.
So just so we're clear, Mr. Mueller, 2 days after the White House counsel, Don McGahn, refused to carry out the President's order to fire you, the President directed a private citizen to tell the Attorney General of the United States, who was recused at the time, to limit your investigation to future elections, effectively ending your investigation into the 2016 Trump campaign. Is that correct?
Well, I'm not going to adopt your characterization. I'll say that the facts as laid out in the report are accurate.
Well, Mr. Mueller, in your report, you in fact write at page 97, substantial evidence indicates that the President's effort to have Sessions limit the scope of the special counsel's investigation to future elections interference was intended to prevent further investigative scrutiny of the President and his campaign conduct. Is that correct?
Generally.
And so, Mr. Mueller, you have seen a letter where 1,000 former Republican and Democratic federal prosecutors have read your report and said anyone but the President who committed those acts would be charged with obstruction of justice. Do you agree with those former colleagues, 1,000 prosecutors who came to that conclusion?
Those prosecutors.
Thank you, Mr. Chairman. Over here. Thanks. Mr. Mueller, you guys, your team wrote in the report, quote, this is the top of page 2, volume 1, also on page 173, by the way. You said that you'd come to the conclusion that, quote, the investigation did not establish that members of the Trump campaign conspired or coordinated with the Russian government in its election interference activities, close quote. That's an accurate statement, right?
That's accurate.
And I'm curious, when did you personally come to that conclusion?
Can you remind me which paragraph you're referring to?
Top of page 2.
On 2?
Volume 1.
Okay. And exactly which paragraph are you looking at on 2?
The investigation did not establish.
Of course. I see it. Yes.
See it?
What was your question?
My question now is, when did you personally reach that conclusion?
Well, we were ongoing for 2 years.
Right, you were ongoing, you wrote it at some point during that 2-year period, but at some point you had to come to a conclusion that that I don't think that there's not a conspiracy going on here. There was no conspiracy between this president. I'm not talking about the rest of the president's team. I'm talking about this president and the Russians.
As you understand, in developing a criminal case, you get pieces of information, witnesses, and the like, as you make your case.
Right.
And when you make a decision on a particular case depends on a number of factors.
Right, I understand.
So I cannot say specifically that we reached a decision on a particular defendant at a particular point in time.
But it was some time well before you wrote the report. Fair enough? I mean, you wrote the report dealing with a whole myriad of issues. Certainly at some time prior to that report is when you reached the decision that, okay, with regard to the president himself, I don't find anything here. Fair enough?
Well, I'm not certain I do agree with that.
So you waited till the last minute when you were actually writing the report and say, "Oh, okay."
No, but there are various aspects of the development of
Sure, and that's my point. There are various aspects that happen, but somewhere along the pike, you will come to a conclusion. There's no there for this defendant. Isn't that right? So apparently,
I can't speak.
You can't say when. Fair enough. So I'm asking the sworn witness. Mr. Mueller, evidence suggests that on May 10th, 2017, at approximately 7:45 a.m., 6 days before the DAG Deputy Attorney General appointed you special counsel, Mr. Rosenstein called you and mentioned the appointment of a special counsel. Not necessarily that you'd be appointed, but that you had a discussion of that. Is that true? May 10th, 2017.
I don't have any. I don't have any knowledge of that occurring.
You don't have any knowledge, or you don't recall?
I don't have any knowledge.
Evidence also suggests.
Given that, what I saw you do, are you questioning that?
Well, I just find it intriguing. Let me just tell you that there's evidence that suggests that phone call took place and that's what was said. So let's move to the next question. Evidence suggests that also on May 12th, 2017, 5 days before the DAG appointed you special counsel, you met with Mr. Rosenstein in person. Did you discuss the appointment of special counsel then? Not necessarily that you, but that there would be a special counsel.
I've gone into waters that don't allow me to give you an answer to that particular question. It relates to the internal discussions he would have in terms of indicting an individual.
It has nothing to do with indictment. It has to do with special counsel and whether you discussed that with Mr. Rosenstein. Evidence also suggests on May 13th, 4 days before you were appointed special counsel, you met with former Attorney General Sessions and Rosenstein, and you spoke about special counsel. Do you remember that?
Not offhand, no.
Okay. And on May 16th, the day before you were appointed special counsel, you met with the president and Rod Rosenstein. Do you remember having that meeting?
Yes.
And discussion of the position of FBI director took place. Do you remember that?
Yes.
And did you discuss at any time in that meeting Mr. Comey's termination?
No.
Did you discuss at any time in that meeting the potential appointment of a special counsel? Not necessarily you, but just in general terms.
I can't get into the discussions on that.
How many times did you speak to Mr. Rosenstein before May 17th, which is the day you got appointed, regarding the appointment of special counsel? How many times prior to that did you discuss?
I can't tell you how many times.
Is that because you don't recall, or are you just?
I do not recall.
Okay, thank you. How many times did you speak with Mr. Comey about any investigations pertaining to Russia prior to May 17, 2017? Did you have any?
Not at all.
Zero?
Zero.
Okay. Now, my time has expired. So,
time of the gentleman has expired. The gentleman from California.
Director Mueller, going back to the president's obstruction via Corey Lewandowski, it was referenced that 1,000 former prosecutors who served under Republican and Democratic administrations with 12,000 years of federal service wrote a letter regarding the president's conduct. Are you familiar with that letter?
I've read about that letter, yes.
And some of the individuals who signed that letter, the statement of former prosecutors, are people you worked with. Is that right?
Quite probably, yes.
People that you respect?
Quite probably, yes.
And in that letter, they said all of this conduct, trying to control and impede the investigation against the president by leveraging his authority over others, is similar to conduct we have seen charged against other public officials and people in powerful positions. Are they wrong?
They have a different case.
Do you want to sign that letter, Director Mueller?
They have a different case.
Director Mueller, thank you for your service, going all the way back to the 60s when you courageously served in Vietnam. Because I have a seat on the Intelligence Committee, I'll have questions later. And because of our limited time, I will ask to enter this letter into the record under unanimous consent. That yield to my colleague from California, Mr. Liu.
All right, they'll continue on here. You're listening to our complete Mueller coverage. We'll continue on in the 10 o'clock hour, into the 10 o'clock hour with this. You're listening to Kevin Miller, KIDO Talk Radio. Let's get you to work safely and on time. Good morning, Dave. No Fox News. Our coverage will continue. No news at the top of the hour. John and Milton, we appreciate you hanging on. We'll take your phone calls if the Mueller hearing concludes before 10 a.m. Then we'll go to Glenn Beck. Back to the Mueller hearings on KIDO Talk Radio.
Yes.
Okay. I'd like to now turn to the final element of the crime of obstruction of justice. On that same page, page 97, do you see where there's the intent section on that page?
I do see that.
C. All right. Would you be willing to read the first sentence?
And that was starting with
Substantial evidence.
indicates that the president's.
Yeah, if you could read that first sentence, would you be willing to do that?
I'm happy to have you read it.
Okay, I will read it then. You wrote, quote, substantial evidence indicates that the president's effort to have Sessions limit the scope of the special counsel's investigation to future election interference was intended to prevent further investigative scrutiny of the president's and his campaign's conduct, unquote. That's in the report, correct?
That is in the report, and I rely what's in the report to indicate what's happened in the paragraphs that we've been discussing.
Thank you. So to recap what we've heard, we have heard today that the president ordered former White House counsel Don McGahn to fire you. The president ordered Don McGahn to then cover that up and create a false paper trail. And now we've heard the president ordered Corey Lewandowski to tell Jeff Sessions to limit your investigation so that you stop investigating the president. I believe a reasonable person looking at these facts could conclude that all three elements of the crime of obstruction of justice have been met. And I'd like to ask you, the reason, again, that you did not indict Donald Trump is because of OLC opinion stating that you cannot indict a sitting president, correct?
That is correct.
The fact that their orders by the president were not carried out, that is not a defense to obstruction of justice because the statute itself is quite broad. It says that as long as you endeavor or attempt to obstruct justice, that would also constitute a crime.
I'm not going to get into that at this juncture.
Okay, thank you. And based on the evidence that we have heard today, I believe a reasonable person could conclude that at least 3 crimes of obstruction of justice by the president occurred. We're going to hear about 2 additional crimes, and that would be the witness tamperings of Michael Cohen and Paul Manafort.
All that, the only thing I want to add is that I'm going through the elements with you does not mean that I subscribe to what you're trying to prove through those elements.
The time of the gentleman has expired. The gentlelady from Arizona. I'm sorry, gentleman from California.
And there we have it. Much more. Our coverage continues. You're listening to Bob Mueller on KIDO Talk Radio.
Today, you had 3 discussions with Rod Rosenstein about your appointment as special counsel, May 10th, May 12th, and May 13th, correct?
If you say so, I have no reason to dispute that.
Then you met with the president on the 16th with Rod Rosenstein present, and then on the 17th you were formally appointed as special counsel. Were you meeting with the president on the 16th with knowledge that you were under consideration for appointment to special counsel?
I did not believe I was under consideration for counsel. I had served 2 terms as FBI director.
So the answer is no.
And the answer is no.
Greg Jarrett describes your office as the team of partisans. And as additional information is coming to light, there's a growing concern that political bias caused important facts to be omitted from your report in order to cast the president unfairly in a negative light. For example, John Dowd, the president's lawyer, leaves a message with Michael Flynn's lawyer on November 17th of 2017. November 2017. The edited version in your report makes it appear that he was improperly asking for confidential information, and that's all we know from your report, except that the judge in the Flynn case ordered the entire transcript released, in which Dowd makes it crystal clear that's not what he was suggesting. So my question is, why did you edit the transcript to hide the exculpatory part of the message?
Well, I'm not certain I would agree with your characterization as we did anything to hide.
Well, you omitted it. You quoted the part where he says we need some kind of heads up just for the sake of protecting all of our interests if we can, but you omitted the portion where he says without giving up any confidential information.
Well, I'm not going to go further in terms of discussing
well, let's go on. You extensively discussed Konstantin Kilimnik's activities with Paul Manafort. You describe him as, quote, a Russian-Ukrainian political consultant and longtime employee of Paul Manafort, assessed by the FBI to have ties to Russian intelligence. And again, that's all we know from your report, except we've since learned from news articles that Kilimnik was actually a U.S. State Department intelligence source, yet nowhere in your report is he so identified. Why was that fact?
I don't necessarily credit what you're saying occurred.
Were you aware that Kalimnik was
I'm not going to go into the
Department
ins and outs. I'm not going to go into the ins and outs of what we had in the court.
Did you
in the course of our investigation.
Did you interview Konstantin Kalimnik?
Pardon?
Did you interview Konstantin Kalimnik?
I can't go into the discussion of our investigative moves.
And yet that is the basis of your report. Again, the problem we're having is we have to rely on your report for an accurate reflection of the evidence, and we're starting to find out that's not true. For example, your report famously links Russian internet troll farms with the Russian government. Yet at a hearing on May 28th in the Concord Management IRA prosecution that you initiated, the judge excoriated both you and Mr. Barr for producing no evidence to support this claim. Why did you suggest Russia was responsible for the troll farms when in court you've been unable to produce any evidence to support it?
Well, I'm not going to get into that any further than I already have.
But you have left the clear impression throughout the country through your report that it was the Russian government behind the troll farms, and yet when you're called upon to provide actual evidence in court, you fail to do so.
Well, I would again dispute your characterization of what occurred in that proceeding.
In fact, the judge, considered holding prosecutors in criminal contempt. She backed off only after your hastily called press conference the next day in which you retroactively made the distinction between the Russian government and the Russia troll farms. Did your press conference of May 29th have anything to do with the threat to hold your prosecutors in contempt the previous day for publicly misrepresenting the evidence?